We are recording.
Okay, good morning, all. Welcome to the appellate court. The next matter we're hearing this morning is AC 43739, United Public Service Employees Union versus the town of Hamden. The first order of business is to have everyone introduce themselves so that we can make sure that we can all see and hear each other. So we'll start with the judges and then counsel. I'm Judge Prescott.
I am Judge Mall.
I'm Judge Suarez.
For the appellant, my name is Glenn Duell of Zangari, Cohn, Cuthbertson, Duell, and Grello.
On behalf of UPSEU Cops, my name is John M. Walsh Jr. from the law firm of LeCarry, Walsh, and Sclaver.
Okay, Attorney Walsh, we cannot see you. Is your camera on?
You know what? Cameras, it says it's been disabled by the administrator. Let me see if I can fix it.
It's like now.
How's that? Can I be seen?
I'm sorry?
I can see. My camera's on now.
Okay. Can everyone see Attorney Walsh?
Yes.
Everyone's indicating yes. Okay. And I'm sorry, counsel for the appellant, Attorney Duell.
Yes.
It indicates on the brief that that Maura Mastronis was arguing the case.
No. We had substituted as counsel. Littler originally was prior counsel. I apologize if we haven't changed that. I thought we may have in our reply.
Yeah, it's on your reply brief, but okay. All right, that's fine. All right. As you all know, we're conducting this hearing on the Microsoft Teams platform. It's a virtual hearing. You should have received instructions along with the link to this hearing. Do you have any questions about those instructions?
No.
No, Your Honor.
Bless you.
Thank you. It's important to remember to keep your microphone muted when you're not addressing the court, but keep your camera on at all times. That helps us know that you're still present and we still have everyone that we need to conduct the hearing. This argument is being live streamed on the Judicial Branch's YouTube channel. And I don't think it applies to this case, but I'll just remind you that if there is any information whose confidentiality is protected by statute, rule, or otherwise, please avoid disclosing it during the hearing. Again, I don't think it applies to this case, but thank you for being careful about that. As you know, each side will have 20 minutes for argument. If you're the appellant and you wish to reserve a portion of that 20 minutes for argument, for rebuttal, please let me know when you begin your argument. I will hold up this very fancy sign when you have 1 minute left in your argument. Very high tech, but we'll do the best we can, and I will be keeping track of the time on my phone. I think we're ready to proceed. So, counsel for the appellant. Now you're muted.
No matter how long we do this, we keep on forgetting certain things. I apologize. I would ask that I please reserve 5 minutes. And may it please the court. This case arises out of a Hamden police officer's use of deadly force on April 16, 2019. Both surveillance video and the officer's body camera show him firing 13 shots at unarmed individuals in a stopped car, and he also grazed the leg of a Yale police officer at the same time. His statements on the scene were recorded. He gave a written statement shortly thereafter to the state police investigation. After his October 21, 2019 arrest, the acting chief of police brought disciplinary actions or charges and referred the matter to the HAMDEN Board of Police Commissioners with a recommendation for employment termination in accordance with the terms contained in a collective bargaining agreement. A hearing was to commence on December 6, 2019. The union thereafter commenced an action for temporary injunction in the Superior Court, claiming Officer Eaton may say something that could be used against him in a pending criminal case. That is, however, why...
Counsel, let me interrupt. The action that the union brought was for both a temporary and a permanent injunction, correct?
I believe so, yes.
Because a temporary injunction, the granting of a or the denial of a temporary injunction is not a final judgment for purposes of appeal. You agree with that, correct?
I believe that's correct.
Right. So we need for this court to have jurisdiction, we need to have a final judgment. And certainly it seems to me an argument can be made that what Judge Blue really did was grant a permanent injunction because there's really nothing left to be decided. Do you agree with that?
Yes, because the terms of what he said was no hearing may proceed until the conclusion of the criminal action.
And there's nothing more in the trial court to be decided at this point, correct?
Correct. Thank you. Now, Judge Blue, by all admission, is an excellent judge, but essentially did not use the right standard here. On a temporary injunction, as we all know and we're all seasoned here, one has to demonstrate no adequate remedy at law. The moving party has to demonstrate irreparable harm unless he or she secures an injunction, likelihood of success on the merits, and a balance of the equities tipping in the movement's favor. Here, Judge Blue acted as if he were to exercise his discretion to stay his own case, not an administrative case that was not before him. And in that regard, the record is clear. He did not go through the standard. And frankly, if we were to go through the standards, as I've done so in our briefs, and my predecessor counsel has done through in the briefs, we would win. HAMDEN would prevail. And we all know it's well settled that both criminal and civil matters may be proceeding concurrently at the same time, and we just do not stay civil matters because of the pendency of an ongoing criminal matter. It just doesn't work that way.
Attorney Duell,
yes.
If I can turn your attention to the appendix A356, paragraph beginning on line 10, the court stated that whether the court has inherent powers to stay the administrative proceedings was discretionary upon the court, and both counsel agreed to that statement.
I don't think that's right. I think that while there is discretion to a judge, the judge still has to go through the standard that the Supreme Court has set forth. And I expect that my predecessor counsel expected the Judge Blue to use the standard in exercising his discretion, not an exercise of discretion to avoid use of the standard. I don't think the Supreme Court allows that. So at the end of the day, the authorities that we cited, for example, in the Second Circuit, upheld the denial of an application for a preliminary injunction halting a disciplinary proceeding, and that's the Nosek case. And I think that this court has done similarly in the Tyler versus Shankman-Tyler, a motion to stay case, but demonstrates no constitutional right in danger. Here, no one is forcing the officer to invoke his Fifth Amendment rights. I'm not sure if he even would do so because of the reason that all the statements that were to be made have been made, are memorialized on video, and I expect the only time that he would want to say anything, well, I won't speculate as to why it may be invoked. I just don't see that the town of Hamden should be barred from proceeding with its right and its entitlement to proceed with a termination proceeding. There was no request by Officer Eaton or his union to the board to stay that proceeding. That was his right. He could have done it. He didn't do so. To the extent that he's going to say, well, that may have been futile, that's an argument that no court accepts. The court basically said, you have a right. You have to exhaust that right. I don't believe that we're going to tie up the superior courts with various injunctions to stay administrative proceedings where there's a criminal action ongoing. It just doesn't work that way. Thank you.
Anything else, counsel?
No.
Okay. All right. Counsel for the appellee.
May it please the court. Good morning, Your Honors. Referring to Your Honor's question, and specifically page A356, it's important to know that in this case, prior to the commencement of the argument before the court was presented with a joint stipulation of facts, was presented with a joint stipulated exhibit list, and also held a pre-argument conference in chambers. So what Judge Blue said on the record did indeed occur. And he also said, which I think is very important, is that he was well aware of the underlying facts of this case and had knowledge of not only from the documents he reviewed, because he did take time to review both stipulations in chambers, but also from that he was familiar with the facts of the case. Now, in this instance, I think it's clear that the court does have the discretion to determine the appropriate standard to be applied in this case. And Judge Blue was very clear.
Counsel, I don't really understand that comment. He has discretion to consider what the appropriate standard is?
Well, Your Honor, in terms of looking at the standard that he applied, I think Judge Blue's rationale was that this wasn't, as in your typical injunction hearing, this wasn't a matter of whether someone was going to win or someone was going to lose. It really didn't have to do with that. And I think that's why he moved to stay the proceedings, because it was a matter of balancing the equities of, is it necessary to go forward right now with the termination proceeding while the criminal proceedings are occurring? And I think his rationale for that, he considered what was the relative harm to the town. The key issue here is the officer's action.
Attorney Walsh, I'm having trouble following the logic of your argument. So let me ask it this way.
Sure.
To what case law or other sources of law do we look to for the appropriate standard by which to measure the application for an injunction?
Well, to measure an application for an injunction, you would look at the cases that apply to applying the
Has counsel frozen for everybody?
Criteria.
All right, hold on, counsel. You're frozen. Can you hear us?
I can. With the court's permission, I can try to call him right now.
That would be wonderful if you could do that. And tell him probably the best thing to do is to exit out of the virtual courtroom and get back in and see if we can pick up where we left off.
Am I back?
You seem to be now.
Okay.
Can everyone see and hear Attorney Walsh? Okay. I froze your time while we lost you. So
Okay.
let me just reorient us. What I was asking you was where do we look in terms of a source of law for the appropriate standard that Judge Blue should have applied in considering the application for an injunction?
Well, Judge Blue was clearly referring to the Harlow, Adams, and Lee versus Harlow, Adams, and Friedman case. And I think
I'm asking you, I'm not asking you what Judge Blue did. I'm asking you where is the law that Judge Blue should have relied upon?
I think the law that he relied upon was the correct standard. I understand it's not, Your Honor, respectfully, I understand it's not the standard for an application for a temporary injunction.
So how is that the right standard?
Because I believe the court, as I articulated earlier, I believe the court looked at this matter as not an instance of a win or lose situation, but whether or not whether the interests of justice required staying the administrative proceedings while the criminal proceedings were pending, given the nature of the underlying proceedings and the fact that the officer was no longer on the streets, he was no longer being paid. So the initial reason why you would move the proceedings to termination would be to take the officer off the streets.
But that's the Griffin Hospital standard, by which an administrative agency and or a court reviewing a decision of an administrative agency uses to determine whether or not a stay should be in place of the decision, because there is no automatic stay typically in administrative proceedings. You agree with that?
Correct, Your Honor. That was, I cited to that case in my brief as an example of where the court exercised discretion in that situation.
But that test is used in an entirely different procedural context than that exists here, correct?
That was used in a different procedure. Yes, it was, Your Honor.
So why isn't Judge Blue committing error by relying upon that standard, which applies in a different context?
Because I believe if you look at, assuming, I know there's a dispute over the standard of review, but even if you look at the review as being plenary as opposed to our argument being an abuse of discretion, is the decision legally and logically correct? And I think
well, you would agree, sir, would you not, that whether or not a trial court applied the correct legal standard is a plenary question, is a legal question subject to plenary review?
I apologize, Your Honor, I couldn't hear the question.
Sure, I'll ask it again. Wouldn't you agree with me that whether or not a trial court applied the correct legal standard is a question of law over which our review is plenary?
Correct, Your Honor. Could you hear me?
Yeah.
Okay. Okay.
All right, Attorney Walsh, if I could ask you a question since we're transitioning here. So on page 7 of your brief, toward the bottom, you make the representation that even a cursory review of the transcript of the proceedings before the trial court confirms it did consider the irreparable harm factor and that the trial court did not abuse its discretion. So, and of course, no trial transcript excerpts are cited thereafter. So can you explain to me how the trial court considered the irreparable harm factor?
I think if you look, Your Honor, at page A358 of the appendix, that's what I was referring to. That it's clear that in the transcript that Judge Blue did understand not only the criteria for an application.
Attorney Walsh, you said A358, 58?
A358, yes, Your Honor.
But my appendix doesn't go up to 358.
Appendix Part 2?
Thank you.
You're welcome.
Got it.
So on that, down towards the bottom, close to line 19, is basically where Judge Blue is talking about he is considering the factors for a temporary injunction and the circumstances in which they would apply. But then he talks about going further, that the question is not a stay of another action. And in doing that, the question isn't who's going to win, as I've said previously. So I think, Judge, what I was referring to in my brief is that Judge Blue did consider the criteria for an application for a temporary injunction. He didn't believe that this case was one of those cases where the irreparable harm factor should be determinative. And he looked at it as a balancing of the equities as to whether or not to make a decision in issuing the stay.
Would you agree that Judge Blue made no finding as to irreparable harm?
I would clearly agree that he did not say that make a finding on the record, but I think it's clear from what he articulated from the bench that he had considered that and didn't think this was a case regarding irreparable harm.
All right, thank you.
You're welcome, Your Honor. So from our perspective, we've argued in our brief that the appropriate standard of review is the abuse of discretion standard under the Halloran versus Town of North Canaan case. I think if you consider that criteria and you look at the cases cited in our brief and the arguments that we've made, I believe Judge Blue did make the appropriate decision. I think he did apply the appropriate standard as it pertains to this case. And I think when you balance the equities, it's quite clear, and I know it was cited in counsel's brief, that this is a weighty issue and is weighing on the town. We're almost a year and a half past the incident itself, the arrest, more than almost 2 years past the incident. And there isn't the typical type of protests that you saw in the very beginning. So the fact that the matter to be accomplished is the officer's off the street, he's not being paid, and that goal has been accomplished. There's nothing further the town needs to do to announce termination. That's not going to change anything in terms of the officer being off the street. He's off the street right now until such time as the criminal matter is disposed of. So I think for those factors, I think Judge Blue did properly, under Lee versus Harlow, apply a correct standard in this case. Counsel is not cited to any cases which indicate that Judge Blue, that his actions were an abuse of discretion or were not legally and correctly sound. That is all I have.
Okay, you have 5 minutes for rebuttal, Attorney Duell.
Thank you. I wanted to follow back to what Judge Suarez had mentioned as far as the question about page A356. Was there some type of an agreement? And I would actually bring to the court attention page A374, which is a follow-up on that, where the counsel for the town stated, I believe the court also does have to look at if there is irreparable harm to the officer in the case, and it's the town's position that there is certainly no irreparable harm. And And basically bookending that, I would also bring to the court's attention as a follow-up to Your Honor's inquiry of opposing counsel as to whether Judge Blue did consider the irreparable harm standard, and on page A376 makes clear that Judge Blue stated that the question of irreparable harm is not one of the factors that the case law that you cite talks about. So I believe that the record is clear that the judge, that Judge Blue was looking at the balancing of the equities, which is one component of the four-part test. He failed to address irreparable harm, and here there was no irreparable harm. If the court were to say that the standard that Judge Blue implemented is now the precedent for all to follow, then we turn the standards on its head, and now no longer are there to be parallel proceedings going forward, and all civil matters are to be stayed pending the outcome of criminal proceedings. That's just not the law in Connecticut. It's not the law in the Second Circuit. It's not the law in the United States. Thank you.
All right. Thank you both for participating in this virtual hearing. Hopefully we'll see you again in the real courtroom in the near future, and we'll take the matter under advisement.
Thank you all.